everyone. My name is Gail Kurtzman, and actually I'm going to just take off my mask so you can see me for 2 seconds. My name is Gail Kurtzman, and I am the Director of Programs and Events at Beth Tikvah Synagogue. On behalf of the Adult Education Committee, I would like to welcome you today for the first of our 3-part series, Straight from the Headlines, with lawyer and researcher Eric Gertner. Today's topic for discussion will be the United States Supreme Court recent decision on abortion. In addition to those with us in person today, we welcome our audience online, who I'm sure are joining us from their cottage. For those online, if you do have questions, please direct them in the chat and we will aim to answer them at the end of the program. And at the end of the discussion, we will also we'll email everyone Eric's source list if you wish to do any further research. And I saw the list, and it's definitely, you'll be looking at all the research for days. I would now like to reintroduce you to Eric Gertner. Eric is a retired lawyer who was the director of research at the firm McCarthy Tétrault for almost 30 years. He is a co-founder of the Supreme Court Law Review and has taught at Osgoode Hall Law School. Eric has also taught many courses on the law and the Holocaust for Beth Tikvah, and we welcome Eric back for this new moderated discussion on topics that are of importance in the news and from around the world. So now I'll hand it over to Eric.
All right. So let me begin by thanking Gail and thanking all of you for coming out in person, and obviously the people online. Thank you for attending as well. It's unusual for me to be speaking in front of a live audience, so this is a real treat in and of itself. And Gail has already explained to you what I'm going to talk about today, which is the U.S. Supreme Court decision in Dobbs and Jackson Women's Health. And in the next 2 top topics I'm going to address in the next couple of weeks, one is dealing with the issue of genocide, focusing particularly on what's happening in Ukraine, but also the history of the law on genocide and what's happened since that law was adopted in the late 1940s and early 1950s. And the last topic I'm going to talk about deals with the uncovering of mass graves. And we are seeing that again in person or happening every day almost. We've seen it recently with residential schools. This week, there was news about a mass grave discovered in Poland of ashes of approximately 8,000 people, which was probably Jews and also Polish aristocracy. And so this is an event that is happening all too frequently, and it's important to understand how these discoveries are made and why they're being made. So that's what I expect to do over the next 3 weeks. And Gail has already given you a little bit about my background. What I'm going to start with is by saying, as Gail said, I was a research lawyer for 30 years at a law firm, McCarthy Tétrault. And before that, I was in practice doing other things for about 7 years. So I've been in practice until I retired in my early 60s for 37 years. And I think the Dobbs decision, which is the US Supreme Court's decision, overturning Roe v. Wade, and therefore allowing states to ban abortions or restrict abortions, is probably the most significant decision in my lifetime as a lawyer and in my lifetime after retiring as a lawyer. Certainly the most important decision in the US since a case called Brown and Board of Education, which is the case that desegregated public schools. So obviously that had a major impact, but I would suggest that the Dobbs decision is likely to have a much more significant impact individually and probably on all of society. It will affect obviously women of childbearing years, but not just those. It will affect their families. It will affect the children that may be born as a result of the ban or restrictions on abortion. It will have a significant economic impact on lots of people, especially women who are forced to carry children to term, and on their families. And I think, as you'll see, those implications are being considered by many, and And hopefully people will start to understand the significance of what is happening if it's not already apparent. And obviously there are significant consequences for society in general in the United States because of the ban on abortions. But I could give you a preview of some of the likely consequences of the Dobbs decision, but I think maybe I'll save that till later. So let me just talk a little bit about the history of Dobbs and what led up to Dobbs. And the American experience with abortion can be divided really into 4 periods. The first period is from 1776, or even before that, I would guess, up until about the 1850s, when there were no restrictions on abortions in any parts of the United States. That was a consequence of carrying over the law, especially from England, which didn't restrict abortions until the early 1800s. So that's the first period. Abortions are unrestricted. Anybody can get abortion. The scene changed in the 1850s, and those bans and restrictions that were imposed lasted basically up until 1950 and 1960, when a number of states started to introduce legislation liberalizing the right to abortion. But what's interesting is why this ban on abortions was introduced at that period of time. And obviously that specific ability of states to ban abortions continued until the Supreme Court's decision in Roe v. Wade. The reason for that ban is not because people were concerned about morality of abortions, particularly, or it was a religious issue. The idea of restricting abortions came up through the American Medical Association. You might wonder why doctors were concerned about banning abortions. Well, it wasn't really about the concern about banning abortions or restricting abortions. It was really a turf war between the medical profession and really midwives and others who were actually performing abortions. So doctors wanted to exclude all these people from providing medical services. And so that's why they pushed to introduce bans on abortion, which, as I said, started in the 1850s and continued in most states up until the 1950s and started to liberalize in the 50s and 60s until we got to Roe v. Wade in 1973. The decision in Roe v. Wade is obviously a very interesting decision, and it needs to be contrasted with the analysis and the thinking of the court in Dobbs. But let me just say this about Roe. And Roe is a much shorter judgment than Dobbs. It's easily readable. Certainly the majority judgment is easily readable. What is obvious from the decision in Roe is that the majority, and remember, this is a decision that was decided by the US Supreme Court in 1973 on a 7-2 basis, 7 members of the court voting in favor of constitutionally protecting the right to abortion and 2 dissenting. What's obvious from the decision is that the chief author of the judgment, Justice Blackmun, was really concerned about the impact of restrictions on abortion on women, on their physical well-being, their mental well-being, their financial well-being, and their social well-being. And there's a great paragraph in that judgment which talks about all the concerns that the court has about the impact of the ban on abortions on women. That's basically the essence of Roe v. Wade. Obviously, they have to find a basis upon which to constitutionalize the right to abortion. And the way that the court did that is focusing on the right to privacy, which had been recognized about 10 or 15 years earlier in a case called Griswold and Connecticut, which recognized the right to obtain and purchase contraceptives without restrictions. And that right to privacy is what was the main basis upon which the Supreme Court in Dobbs attacked the Roe decision. Basically, what the court in Dobbs said is there is no right of privacy as such in the Constitution. It's obviously been read into the Constitution. And even though the court says we're only dealing with abortion here, there are many other rights that have been recognized since Roe, which are also based on the right to privacy. Those include the right to same-sex marriage, the right to homosexual sexual relationships, and other rights as well. But the majority in Dobbs focuses on this. Well, there's nothing in the Constitution that specifically refers to abortion, without recognizing or mentioning that there are many other rights that the Supreme Court over the years has recognized, which are not expressly recognized or expressly stated in the US Constitution. And just to give you an example, which will come up later, there's generally recognized a right of people in the United States to travel within their state, to travel from state to state, to travel out of the country, to return to the country. There is nothing in the US Constitution, nothing in the Bill of Rights that specifically and expressly recognizes the right to travel. There's also no specific provision in the Constitution or the Bill of Rights that says you have a right to a lawyer when you are arrested. That's also a right that Supreme Court decisions recognized under the rubric of liberty in the 14th Amendment, which is an amendment introduced after the Civil War. So the Dobbs decision, I would say, and I think others have said this as well, really is in sharp contrast to Roe, because in Dobbs, Mr. Justice Alito really makes women sort of an abstraction to the decision. It's not really focused on the impact on women. It's focused on this allegedly moral issue arising out of the right to abortion. And he talks a little bit about this issue of moral right, and talks in terms of the unborn human beings, which in itself is a loaded phrase for the US. So it's important to understand that. But what he also says, and I think it's important to recognize this, is he says that Roe, this is now 50 years, almost 50 years after Roe was decided, was egregiously wrong. It wasn't just wrong, it was egregiously wrong. So I think it's important for you to understand a little bit of the statistics behind Roe and behind the next other important case dealing with abortion, which is a case called Casey and Planned Parenthood, and also the decision in Dobbs. So let's start with Roe. As I said before, Roe is a 7-2 decision, 7 judges in the majority, 2 judges dissenting. Of the 7 judges in the majority, 5 are Republican appointed judges, appointed by Republican presidents, 2 are Democrats. In the dissent, there's 1 Democrat and 1 Republican. So we now have 5 Republican justices in Roe saying that abortion is a constitutional right. Casey and Planned Parenthood, there is a 5-4 decision affirming Roe. So when you might have seen clips of Brett Kavanaugh in his hearings when he was about to be appointed to the Supreme Court saying that the right to abortion is a precedent upon a precedent. He was talking about Roe, and then the precedent upon the precedent is this case called Casey and Planned Parenthood. The decision in Casey and Planned Parenthood is 5-4. All 5 justices in the majority are appointed by Republican presidents. There are 2 Republicans in dissent and 2 Democrats in dissent. So we now have 5 in Roe v. Wade and 5 in Casey. So there's 10 judges who have said, 10 Republican appointed judges who've said that abortion is a constitutional right. Then we get to Dobbs, and Dobbs is a decision which is split, I would say, between 5, 1, and 3. There are 5 judges who are Republicans. The 1 judge is the Chief Justice Roberts. He doesn't agree with the 5 that you should overturn Roe. He is prepared to recognize the validity of the Mississippi statute, which was at issue in Dobbs, which restricted abortion to the first 15 weeks of a pregnancy. He said that's as much as we need to do. That's the only issue really that the court should address. And of course, we have the 3 democratically appointed judges dissenting. So if you added up all the numbers, there's actually a majority of Republican judges in these 3 major cases who have favored recognizing the constitutional right to abortion, and a smaller number of Republicans who say that Roe is wrongly decided and there is no constitutional right to abortion. So it's important to understand this huge swing on the part of the Republican appointed members of the Supreme Court of the United States. So I think it's important and useful to think a little bit about the statistics surrounding adoption. And I'm going to talk a little bit about the Canadian scene first, and then talk more about the American scene. And I'm also going to talk about how abortion is treated constitutionally in Canada, because that's, from our perspective, important. So where does the constitutional right for an abortion exist in Canada? It exists because of the Charter, but there is no constitutional provision that specifically addresses the right to an abortion. What happened is that there were obviously a number of cases dealing with the restrictions on abortion in Canada. And so again, let's talk a little bit about the history. Abortion is banned in 1869 after Confederation, and that ban is in place until about 1969, when abortion law is liberalized. We have therapeutic committees set up in the hospitals who are to decide whether a woman should or should not be able to get an abortion. It's that provision in the criminal code. So if you got an abortion without going through a therapeutic committee approval, you are in violation of the criminal code and therefore could be punished criminally. The attacks on the restriction, limited as it was in the criminal code, start in the 70s. And obviously the main leader of this attack on the criminal code restrictions on abortion is Dr. Henry Morgentaler. And Henry Morgentaler is charged criminally for providing abortions, obviously without going through a therapeutic abortion committee. And ultimately, he's convicted originally. And later he challenges the provisions in the criminal code on the basis of the Charter, which is introduced in Canada in 1982. And in 1985, the Supreme Court strikes down the provision in the criminal code criminalizing abortions and restricting abortions to situations where you get consent from the Therapeutic Abortion Committee at a hospital. And that decision, again, is I think it's 7-2 ultimately, with 2 dissenters. And the case is basically decided on the basis that the restrictions on abortion impact a woman's right to liberty, which is protected under Section 7 of the Charter of Rights and Freedoms. And the court also has to do an analysis under Section 1 to determine whether the law as it stood was a limitation, a reasonable limit prescribed by law, consistent with the principles of fundamental justice. And the majority in the Supreme Court says Section 1 doesn't apply, the law can't be saved, and therefore there are no restrictions on abortions in Canada at all. It's not constitutionally recognized other than the law has been struck down. There's no express provision that says you were entitled to an abortion, which of course means that in the future, it is possible for Parliament to enact laws that might restrict abortion, which still would have to pass muster from a challenge, which also would raise issues about Section 1. But if there was a party in power who really wanted to limit or exclude the right to abortion, they could do that by exercising what's called the notwithstanding clause in the Charter, which allows Parliament to say, notwithstanding that this is a violation of the Charter, we think this law should stand, and their decision remains in place for 5 years, which is generally considered to be the lengthened time or the life of the Parliament. And after 5 years, that protection would expire, and the next Parliament might continue it or might decide to remove or not reintroduce the notwithstanding clause. So Canada has no express protection for abortion, but it's recognized that abortion is illegal, and there are no time limits. So you can have an abortion, a late term abortion, you can have early term abortions, you can have abortions in the 2nd trimester, no restrictions whatsoever. Having said that, it's clear that the vast majority of abortions in Canada take place either in the 1st trimester, where most abortions take place, or in the 2nd trimester. there are very, very few abortions that take place in the third trimester. There are approximately 72,000 abortions a year in Canada. About 1,000 of those abortions take place in the last trimester of a pregnancy. So that's just sort of a general outline of the situation in Canada. What's the situation in the United States? So before Dobbs, what's interesting is that up until 2017, there had been a steady decline in the number of abortions in the United States. And depending on which institution's figures you look at, there's an institution called the Guttmacher Institute, which estimates that the high point of abortions in the United States, there were 1.6 million abortions a year in the United States. The CDC figure is much lower, but still quite significant, still over 1 million. And there's a steady decline until 2017, and it starts to increase again after 2017, and particularly in the last couple of years during the pandemic, there were increases in the number of abortions in the United States. What's the figure in the United States? As I said, in Canada, it's about 71,000 a year. In the United States, depending again on whose figures you look at, you're either looking at over 900,000 abortions a year. From that information comes from the Guttmacher Institute. The CDC estimates the number of abortions a year is about 650,000. The Guttmacher Institute's numbers come from significant efforts to obtain information from doctors and clinics and hospitals around the country. I'm not sure the CDC's statistics are as accurate, but anyway, we know it's somewhere between 900 and 950,000 to 650,000, which is somewhat in line with the Canadian numbers. If you multiply the Canadian number of 71,000 by 10, which is the difference in the population approximately, you would get to 700,000. So there's still a lot of abortions that have happened in the United States up to Dobbs. And of course, the number of adoptions in any given state varied quite significantly. The highest number can be found in the District of Columbia, where 23.9 abortions for every 100,000 women occur. I think it's 100,000. Just hold on, let me double check that. No, it's per 1,000. So it's 23.9 for women between the ages of 15 and 44. In some states, like Wyoming, the number is 0.3%, 0.3 abortions per 1,000 women between the ages of 15 to 44. So there's a quite significant difference, which of course is now being reflected in the impact of Dobbs and what's going on legally in a variety of different states to change the law and to limit or restrict or ban abortions entirely. So I've given you a little bit about the history of the United States. So I've talked about the first period, there's no restrictions. 1850 to 1973, there are restrictions. 1973 to this past year, there are restrictions, but abortions are generally available. And now we're in the fourth period of the United States history since 2022. There are significant potential restrictions on abortion on a state-by-state basis, relying on Mr. Justice Alito's decision, which says this is a moral issue, and the best place to decide this moral issue is on a state-by-state basis. Obviously, commentators have said, well, if you're looking at the moral issue, you actually should look at it on an individual-by-individual basis. Who is closer to the moral issue than the women affected by these restrictions? The other thing that Alito says in his judgment is where he does talk about women and their ability to sort of control this issue, is he says, well, women have a right to vote. They have a right to vote in every state. They can overturn the law in the state. Well, this is a pretty fanciful argument on the part of the majority in the Supreme Court. having regard to the fact that the US Supreme Court over the last 10 or 15 years has significantly watered down the Voting Rights Act, which was intended to protect the right to vote, especially for minorities. And that's been continuing up until the last year. And even where there is a right to vote, which is unrestricted, it's also important to remember that a lot of states, not just Republican states, but Democratic states also, gerrymander the election to ensure that as many representatives from their party, if they're in control of the state, are able to be elected versus the other party. So you'll get states where, there's a significant Black population, where if they were properly represented, they would have 4 seats. They actually are able to elect 2 people because all the Black people are set into one congressional district so as to limit the impact of Black voters on the ability to control the electorate in the state. So Alito's comment is pretty fanciful, and I think a lot of people have pointed that out. And as I said, he says this is a profoundly moral issue because we're dealing with unborn human beings. Now, I don't know what an unborn human being is, what rights an unborn human being has. That's not really carefully delineated. What Alito says is they have a right to be born, I guess, or they have a right on the part of the states to determine who should be born or what circumstances they should be born. I would have thought if this is a moral issue, you would say every fetus has the right to be born. You treat life as sacrosanct, but that's not what he's saying. It's the states should have the right to decide this moral issue. And of course, that raises all kinds of issues about morality. And is this really an issue about morality, or is this really an issue about religion? And of course, we know that the people who have been pushing for restrictions or the banning of abortions are basically fundamentalists in the United States and Catholics in the United States. The other religions are not terribly represented. Certainly on the court, there are 2 Jews, now only 1 Jew. But the rest of the members of the court are either Catholic, or I think one of them is Episcopalian. So I think this moral issue is really tied up into religious beliefs. And we're going to come back to that in a minute to see how the Supreme Court might deal with the objections of other religions to the restrictions on abortions that might exist in a state. What we have seen, of course, is this ability or desire to control abortion and control women's bodies, in effect, takes different forms in different countries. As I said, Canada, we have basically an unrestricted right to abortion. United States, we have a number of states. There are probably 20 states that allow abortions, 26 or so states that are going to ban abortion or restrict abortion. There are two or three countries to look at which have an interesting history. Ireland perhaps is the most interesting. Ireland, a mainly Catholic country, basically restricted abortions to the extent that if you look at historically before 2018, the number of abortions that took place in Ireland was in double digits. That means less than 100 abortions a year. Actually, it was never even close to 100. It was like in the 20s and maybe 30s. And of course, that started to change and was particularly impacted by decisions of to refuse abortions to women who ultimately died as a result of their failure to obtain an abortion. And of course, what was happening in Ireland was happening in Ireland, but Irish women were not restricted in the ability to get an abortion by traveling to the UK, which is basically less than an hour's flight away, maybe a couple hours by ship. So that even though there were very few abortions that took place in Ireland at all, the number of abortions on the part of Irish women was in the 4,000 or 5,000 range a year, getting most of these abortions either in the UK or in the Netherlands. Because of what happened in 2018, there was a move to change the law. It was done by a referendum, and the law was amended to enable abortions to occur and take place in Ireland itself. So the number of abortions now is somewhere in the range of 7,000 a year, but they clearly moved from one extreme to another. The US is going the other way. The other country to look at is another Catholic country, and that's Poland. And Poland, again, after the communist takeover in 1945 or 47, they basically had an unrestricted right to abortions. Under the modern Polish regime and constitution, they've cracked down on the abortions. They've restricted the ability to get abortions. They do have some exceptions, which allow women to get abortions, like rape, incest, and the health of the mother. But despite the crackdown on abortions and the turning these abortions into something that's illegal, there are significant numbers of Polish women who are able to get abortions by traveling out of Poland and into other countries, mainly Germany and Czechoslovakia. So it's estimated there's something like 150,000 to 300,000 abortions on the part of Polish women that occur each and every year. Interestingly, Israel, which had allowed abortions, has recently even more liberalized the law on abortions. And of course, Israel is some would say a theocracy with a significant religious minority who has a lot of power. They may not be happy with the result, but we know what's happened recently. In fact, right after Dobbs is the Israeli government introduced new laws to liberalize abortion significantly. So what's the likely impact of the decision in Dobbs? We know that there's going to be a division between the 50 states. A majority probably will ban entirely or significantly restrict abortions. The restrictions may be up to 15 weeks, which was the original decision, original legislation at issue in Dobbs. Some cases it's 6 weeks, some cases it's 8 weeks, and some cases it's a total ban. Some states that are restricting abortion, restrict abortion, but have exceptions for rape and incest. A lot of them have exception for the life of the mother. It's not the health of the mother, it's the life of the mother. So if the mother's life is in danger, she may be able to get an abortion. There are some states that aren't even going to have that exception. So it's really one life, the life of the unborn human being versus the existing life of the mother. And you can tell me which one has the higher moral right to live, because that's basically what they're deciding. They're deciding that based on the Supreme Court saying this is a moral question, the state is deciding that the life of the unborn human being is more important than the life of the mother. So even in the short time since Dobbs, we have seen the real world impact of the Dobbs decision. And I'm sure many of you have either heard about or read about the 10-year-old girl in Ohio who was raped and became pregnant and was able to travel to Indiana and ultimately was able to get an abortion. But can you imagine the trauma on a 10-year-old girl who, first of all, is raped and is now potentially being forced to carry that pregnancy to term, if that was ever going to happen in the case of a 10-year-old girl. So that's a real world consequence. The result of her obtaining the abortion was that the Attorney General of Indiana berated the doctor who performed the abortion, saying that she didn't comply with the law in Indiana, which allowed an abortion to be performed. And of course, it was totally incorrect what the Attorney General said. The doctor had fully complied with notifying the state offices of this abortion. So this was an attempt to scare off perhaps other doctors or to deal with this doctor without knowing all the facts. and obviously impacting her character and her professionalism. That's just one example. There's a significant potential impact, like that case showed, on all health professionals. How do you know when it's okay to perform an abortion to save the life of a woman? How close to death or serious health impact does the woman have to be before a doctor can feel safe in performing an abortion? And again, this is a real world problem that has already raised its head over the last few weeks. There are a number of doctors who have hesitated to treat women having a miscarriage, perhaps believing that the miscarriage was brought about by the woman herself attempting to abort her fetus in her pregnancy, or it was just concerned that, oh, I don't know what's going on here, so like, I don't want to touch this because, you know, I'm at risk criminally if I do something that's contrary to the law, banning abortions or restricting abortions. And there's a story that I read where a woman with a miscarriage was sent home by the hospital twice to wait and see what was going to happen. This is not proper medical treatment, I would suggest. I mean, I'm not a doctor, but just seems from a reasonable person's point of view. If a woman is having a miscarriage, you need to deal with that miscarriage, regardless of what the basis for the miscarriage might be. Perhaps the most significant consequence of Dobbs is its social and economic impact on not just women, but on women and their families and on the United States in general. Obviously, in part because of Roe v. Wade, women have taken on a much greater role in society than had been the case before. There's a significant number of women who are employed. You know, they're not earning as much as their male counterpart. But just from my own experience, I went to law school in 1971. Mine was the first year in which a third of the class were females. Now, most law schools, more than half the class would be females. And so they've taken a significant role in the economy. Having to deal with an unwanted pregnancy, having to deal with the economic consequences of an unwanted pregnancy, will have a tremendous impact on the women and their families, and also importantly, on the child that might be born as a result of that unwanted pregnancy. And that obviously will have repercussions going forward. It sort of reminds me, it's not obviously the same thing, of new studies on the impact of the Holocaust. There's this whole area of study called epigenetics, which says that the impact on the Holocaust survivors is actually causing their genes to be altered, and those altered genes are passed on to their children with the consequences that might follow. And we can see that as well in the Indigenous population in Canada, who have for 300 years been carrying forward this trauma of residential schools, their treatment at residential schools, their physical treatment, their sexual treatment, and their loss of their culture. All of that is having a real world impact. Let's think about some of the other things that might be impacted. We know that over the last 20 years or so, there are many couples who have been unable to have children, who have resorted to medical procedures to enable the woman to become pregnant. One of the most popular procedures is artificial insemination. Another one is IVF. And you've all heard of IVF, where the egg of a woman and the sperm of a man is combined, and ultimately those zygotes are frozen until the couple is ready to have a child and have that implanted in the woman, and she can carry the child to term. Or sometimes they would use a surrogate. So what happens with all these fertilized eggs? These are unborn human beings under Alito's decision in Dobbs, because there are many people in the United States, and apparently also in the Supreme Court, who believe that life begins at conception. So in the case of IVF, that happens when those two elements are combined in a petri dish and then frozen. So we don't even know how many potential human beings or unborn human beings are in the offices of IVF facilities in Canada and in the United States. So what's going to happen? Well, we know generally IVF parents don't want to have all the children that they can have from their egg and sperm that's been fertilized. They may want one or two, but the eggs, eventually the eggs will be destroyed in many cases. The parents will get divorced and there will be a fight about whether they can be used or not used. But of course, every fertilized egg now would constitute an abortion. And a facility that stores these fertilized eggs are going to be mass murderers when they allow the fertilized eggs to be destroyed. What's going to happen to those situations? What will happen to IVF clinics if that is in fact the result? So obviously a lot is happening in the United States. It's only 3 or 4 weeks since Dobbs. I think it's less than 4 weeks. And we've already seen a tremendous amount of legal activity in the United States to deal with the consequences of Dobbs. There's obviously a lot of fighting between the Democrats and the Republicans. Everybody's trying to stake out territory. Everybody's trying to make a statement or a point, obviously with an eye to the elections that are going to happen later this year and the elections that will happen thereafter. We see the federal government or federal legislature doing a bunch of things which most people don't expect will ultimately come into law. The Democrats in the House of Representatives, where they have control, have passed a number of pieces of legislation in response to Dobbs. One of these pieces of legislation is called the Respect for Marriage Act, and it's intended to deal with same-sex marriages. And I'll explain why that happens in a moment, or why that happened in a moment. And part of that legislation is the repeal of something called the Defense of Marriage Act, which was passed under the Bush administration, which is still on the books as law, but obviously has been overtaken by the Supreme Court's decision recognizing the validity of gay marriages on a constitutional basis. Why do we have this Respect for Marriage Act? Because Justice Clarence Thomas, who was in the majority, decided to write his own opinion, which was not in itself uncommon. But in the course of that opinion, he says, well, now that we've struck down Roe, and now that we said that Roe is not supported by the right of privacy, upon which it was based, there are all kinds of other things that have also been constitutionally recognized as a result of that right of privacy. They include the right to contraceptives, so you can't restrict the sale of contraceptives, the right to same-sex marriage, the right to homosexual relationships. The only privacy case that he didn't address, either specifically or generally, is the law that struck down restrictions on interracial marriages. And I wonder why he did that. Well, we know because he's married to a woman who is white and he's Black. So he'd be attacking his own marriage. So the Democrats in the House of Representatives have pushed this Respect for Marriage Act, obviously in response to what Clarence Thomas is perhaps warning is going to happen in the future. The main decision, as I said, is written by Justice Alito. He says, we are only deciding the abortion issue in this case. We're not deciding anything else. But you can't take him at his word because the abortion decision is based on the right to privacy. All these other rights that I just talked about are all based on the same right of privacy. I don't know how you differentiate those cases from the case of abortion. And he says, well, it's different because we're dealing with unborn human beings. I'm not sure that's going to be a significant difference when it gets to the Supreme Court, and especially the religious majority on the court. In response again to the Thomas decision or judgment, the Democrats have also introduced and are passing an act called the Right to Contraception Act, which is, again, to deal specifically with the right to contraception, which was recognized by the Supreme Court in the Griswold and Connecticut case. They're also enacting or hoping to enact an act called the Ensuring Access to Abortion Act, which is more or less directed to dealing with the right of women to travel across state lines to get an abortion. And there are obviously many states that are next to states where abortions are permitted, and in their state it's banned. So women obviously can travel. Interestingly enough, while lots of commentators have said, well, the right of travel is obviously recognized by the Supreme Court of the United States, you know what? It's not expressly stated in the Constitution or the Bill of Rights. So it's like abortion. So maybe the right of travel will also be struck down. The other piece of legislation that the Democrats are pushing is something called the Women's Health Protection Act, which is aimed at protecting the doctors in states where abortions are permitted from being charged criminally by states where that woman is resident and from where she's traveled to obtain her abortion. And of course, that is consistent with the constitutionally recognized right of travel. But if that falls by the wayside, this legislation would then kick in. Yes. Okay, just a few more points and we'll get on. We'll get to questions. On the state level, so those are all federal legislature issues. At the state level, we have pro-life states that are obviously pushing legislation to give effect to the Dobbs decision in whatever way, shape, or form they think is appropriate with their moral responsibilities. There are mostly Democratic states, but not entirely, states that are where abortions are now allowed, which are pushing legislation to protect that right. And there are some states that are where there's a movement to amend the state constitution to specifically and expressly recognize the right to privacy, which is not recognized in the American or US Constitution. And there are other states that are seeking to amend the legislation to remove the constitutionally protected right of privacy. So it's actually chaos, I would say. And on the regulatory front, again, Biden was being pushed to help protect the right to abortion, and he's introduced a number of measures, which I can talk about if it's appropriate when some of the questions are raised, which hopefully will have also an impact to protect the right to abortion in a number of jurisdictions. So I'm happy to entertain any questions.
So let's ask Daniel, who is monitoring our online. Yes, did people have comments online?
Not yet.
Okay, because I have a question.
I knew that.
So I guess in order for the people online to hear, I guess you'll have
I'll repeat.
Some people are angry with Ruth Bader Ginsburg. First of all, I want to get your take on how she plays into it, but didn't she also say that Roe versus Wade was flawed?
I don't know if she said it was flawed. I think she said there was probably a better way. Sorry, the question was in reaction to how Ruth Bader Ginsburg stayed in her position and ultimately resigned at a time when there was a Republican president, which enabled her position to be replaced by a Republican appointed nominee and justice. And there's a question about whether she herself recognized that Roe was flawed. And I think she did recognize that it may not have been the best way to address the issue of abortion from a constitutional perspective. And of course, she doesn't have control over how the justices ultimately decide the case, because I'm sure there was more than one argument. in Roe versus Wade. She didn't argue the case. So yeah, even if it's flawed, it doesn't mean it's fatally flawed. Again, you have to recognize Roe was in existence for almost 50 years. It was reaffirmed in Casey in 1992. There are approximately at least a dozen cases in which abortion restrictions were introduced and challenged, and none of those cases closely suggested that Roe was egregiously wrong, let alone wrong.
So it's almost like imagine if she had died just a week or 10 days later.
The world might be different.
Exactly.
Well, it might not. I mean, here's the sort of interesting thing. Justice Roberts is obviously a conservative, but he is also somebody who is concerned about the Supreme Court as an institution. And ordinarily, what the Supreme Court cases tell you is they generally only decide a case to the extent it needs to be decided. So the statute at issue in Dobbs imposed a 15-week restriction on abortions. If you were truly a conservative justice, as Roberts is, you would say, okay, fine, we can uphold this legislation. We can remove the restriction from 24 weeks where it's generally available. There's a much harder and higher standard when you try to get an abortion after 24 weeks. But we don't have to deal with the whole thing, not in this case, because the legislation at issue doesn't ask for that. And he said that. He says his decision. So when I describe the result in Dobbs, it's the five conservatives, 1 Roberts, who takes a very different view, and the 3 dissenting justices who say there's nothing wrong with Roe and we should continue. And here's all the repercussions if you do deal with and ban abortions. I think Ruth Bader Ginsburg raises another issue for me. I mean, I've got notes on it and I didn't really raise it. But if you look at who has been pushing changes to abortion law over the last 50 years or so, I'm going to go back even further, 80 years. There's a doctor who is in Auschwitz, whose name is Gisela Perl. She wrote one of the first books about her experience in Auschwitz, where she was a doctor. She recognized that any woman who became pregnant would immediately be killed. So she helped women to have abortions so they might possibly survive. So there's sort of the classic example of there's a woman here, she is pregnant with an unborn human being. If that's detected, she dies. So her decision was to save the woman because likely the child was going to be killed anyway. But this way, for sure, she at least tried to save the woman. So there's Gisela Perl. In Canada, who's the main proponent of legalizing abortion? Dr. Henry Morgentaler, who is also a Holocaust survivor. In France, the main push behind abortion was Simone Weil, also Jewish, also from the period of the Holocaust. I don't think she was in a camp. And of course, if you look at the women who pushed for abortion to be legalized in the United States, you have a whole bunch of feminists, not all Jewish, but obviously there were a significant number of Jews represented in that group, including Betty Friedan, Gloria Steinem, and others. So Jews have taken a very important role in the push to legalize abortion and keep abortion legal. They're on the wane now. It's another group that's now in ascendance, and it's the fundamentalists and the religious groups in the United States. What's really interesting is that when Roe was decided, were there immediate objections to Roe on the part of the fundamentalists? The answer is no. Basically, for 6 years, they said, abortion's fine. Even Catholics, some Catholics supported the right to abortion. Just before 1980, the moral majority recognized that abortion could be an issue that they could push to gain control of state legislatures and ultimately the federal government. And that's how abortion became the giant issue that it has been over the last 40 years.
Is anyone else?
Yes.
Marlene?
Could you comment on what this decision does towards the politicization of the court? Because that's been up there in the,
Yeah.
and there's been a lot of talk around that change.
Mhm. So the question is, what does Dobbs suggest about the politicization of the US Supreme Court? I don't think, in my opinion, as a student of the Supreme Court of the United States and the Supreme Court in Canada, there's no doubt that the court now is much more highly politicized than it was certainly at the time that Roe v. Wade was decided, and probably the most politicized it's been since the 1930s, when Franklin Delano Roosevelt was trying to push his New Deal legislation and was constantly being challenged and overturned by the US Supreme Court. And that continued until he threatened to pack the court. And then all those conservatives said, oh, okay, we'll be good. And many of them started to retire and got replaced, and the New Deal went through. I think the court is highly political, just from the statistics I gave you of those three cases. But it's not just those three cases. The approach to freedom of religion is significantly different. The approach to recognizing the rights of corporations has been going on for about 20 or 30 years now in the United States, led in part by Justice Roberts. There are a whole bunch of issues. They're not reluctant as they have been, or at least as reluctant as they have been in the past, to overturn long-standing precedents. That's happening with a fair degree of regularity. And I think the alarm bells went off when Justice Thomas included his concurring decision in Dobbs, where he said, all these things, these other things that we as conservatives hate, they're up for grabs. So
At a similar time, they made that decision about guns in New York.
Yeah. Yeah. So what's the relationship, if any, between the decision dealing with limitations on the right to carry openly guns in New York State, or rifles in New York State, and this decision? Well, Dobbs is a case which pushes states' rights. States should have the right to decide what happens with respect to abortion in their state. New York State had their own law about guns. Well, the right to carry guns is different, maybe because under their interpretation, there's a right to carry guns on the part of individuals recognized in the Second Amendment, which, by the way, isn't there expressly. Never been there expressly. It's the court's interpretation based on what they thought the founding fathers thought about this issue in 1776 or 1789 when the Bill of Rights is introduced. So, they're sort of going in different directions depending on the issue, which to me tells me that there's no philosophy other than a conservative intention to change the decisions of the US Supreme Court to make them much more conservative, to push the conservative agenda. And that's been the aim of the Republican Party and their financiers for certainly the last 40 years.
We have a question.
Yeah.
Does the Hippocratic Oath give every doctor the obligation to treat a woman experiencing spontaneous abortion or elective abortion if her health requires one?
So I don't know if everybody heard that. It's about the Hippocratic Oath that doctors take, and what's their responsibility to a woman who's having a sudden miscarriage or problem with her pregnancy. Well, the Hippocratic Oath imposes a duty on the doctor to do no harm. Okay. And of course, doctors who fail to respond to a medical emergency and something bad happens will get sued. On the other hand, they think they might be charged criminally if somebody thinks that they performed an abortion when it wasn't allowed. So they're stuck in the horns of a dilemma. And so there's efforts on the part of states where abortions are permitted to protect doctors performing abortions in those states or providing medical treatment, that they can't be attacked by courts in other jurisdictions where the person may have been resident before they went to get an abortion. It also raises it. So there's a whole issue of extradition. Can states extradite somebody from one state to another state? Well, it's pretty easy to do that unless there's some kind of protection. It's much more difficult to extradite somebody from another country. And that's a complicated process. And Canada has basically said, hell no, nobody who has an abortion in Canada who comes here from the United States will be extradited by the Canadian government, period, full stop. So there's another issue that's being raised. What can happen to Canadian doctors who undoubtedly some people will come to Canada in some areas to get an abortion? I think there was another question somewhere. Gail, you always have good questions.
Yeah, I do have. I am going to push back, I guess, a little bit
Mhm.
because you can see the point of, I don't think anybody, encourages women to have late-term abortions.
Of course.
And I think Roe versus Wade, I thought, tried to understand that balance.
It did.
And did have some limits that once, in the first trimester, it is a woman's privacy to her own body. And then as the pregnancy
Right.
progressed. But it's just shocking that this decision, you're right, goes completely in the opposite direction.
Yeah.
And
Here's another statistic. The vast, vast majority of abortions in the US occur in the first 12 weeks. So there are some that happen in the 12 to 24 week period, and there are obviously some, but a much, much smaller number.
but in 1973, when Roe versus Wade came into effect, the I guess the age of viability was much higher. Now, as technology is helping, I mean, what is the age of viability? And maybe the law should reflect.
The age of viability, as I've read, is
It's not
21
30
weeks.
anymore.
no, it was never really 30 weeks. I mean, even at the time of Roe, there were probably fetuses at 26 weeks that were being saved. So I think the science today suggests 21 weeks. That's probably viability, obviously with extreme measures necessary to keep that baby alive at incredible cost.
But do you think that, I don't know, somewhere down in the future that the court will come to like some sort of?
No,
No.
I don't think so. I think the other point I'm going to make is with respect to, because I've emphasized the religious makeup of the court. And this is obviously a decision driven by what I would call a religious minority in the United States. Those are the people advocating for restrictions or bans on abortions. Not every religion has taken the same view about pregnancies and abortions as the Catholic Church or the fundamentalists have taken. So one of the interesting fights I think that will happen in the future is, and there's already a case that's been brought in Florida by a rabbi saying, Dobbs is great if you're a fundamentalist. We're not fundamentalists, we're Jewish, and we actually believe that women should be able to have abortions up to the point of quickening. That's sort of what the halakha rules say. And quickening is perhaps 4 or 5 months. So that case is going to go forward. What's interesting about it, and there have been a bunch of articles, some of which are in the material I've sent you, taking different views on how a court is going to deal with that. What to me is fascinating is this particular court with this particular makeup has really moved a lot on freedom of religion. So, you can't make a baker provide a wedding cake to a homosexual couple because you were interfering with his freedom of religion. The court this past term allowed accepted a challenge by a high school football coach who was disciplined because he decided to pray at the end of a game on the field, surrounded by his players. Now, that case is really interesting because the majority's view of the facts is like 180 degrees different from the minority's view. You know, speaking as someone who went to a public school, speaking as someone who lives as a minority in a non-Jewish community, if you can't recognize that people in minorities feel pressure from the majority to do as the majority is doing, you're living in a fantasy world. Do you believe that those football players all were happy to be praying with the coach? But the choice was, you know, if I don't pray with the coach, maybe I won't get as much playing time. Maybe I'll be on the bench. So to me, you know, they've really gone a long way to remove the shackles that they believed were imposed on freedom of religion by earlier courts. But the result might be that when this challenge comes from this rabbi, how do they deal with that? Because you know what, if I'm a Jewish woman and my religion says I'm entitled to have an abortion up to 20 weeks, let's say, or 16 weeks or 15 weeks, whatever it is, why should your religious views supplant mine? I think that's a real question that's going to have to be addressed. It will be addressed.
Daniel, just go.
Why couldn't justice get away with not? The other thing is,
Yeah.
why his parents' Thomas get away with it.
I don't, well, I can understand. I'll explain why Clarence Thomas is able to do what he does, which to me it's ridiculous. The Supreme Court of the United States does not have a code of ethics. Can you believe that? No, I mean, it's ridiculous. That means a judge could sit on a case which impacts that judge's financial interests. It's up to the judge, him or herself, to recuse himself or herself. That to me is insane. It's totally contrary to the rule of law and the principles of natural justice. Whether they lie, well, I think if you parse the language of some of them, like Alito, I don't think Alito lied. I think Kavanaugh lied because he says Roe is okay, it's longstanding precedent, and Casey is precedent upon precedent. All of a sudden, it's okay. It's like 4 years later. Incomprehensible. Of course, he's testifying under oath, but there might be other things he lied about under oath as well.
There was a question, any comments on the decline in respect for the judiciary and rule of law in US, Canada, or elsewhere?
Well, I think the US, well, I don't think it's just the US, but let's focus on Canada. I don't think that there's been a fall in the respect of the rule of law in Canada. There has been obviously on the part of some members of the community, as we saw with the truckers strike and their actions, not just protesting, but bringing a city's downtown to a halt and taking advantage of people in Ottawa. In the US, clearly the polls show that the respect for the US Supreme Court has dropped significantly as a result, not just of Dobbs, but of a long series of cases over the last 5 or 10 years. That's probably not helped by the fact that there was a president in power for 4 years who had no respect for the rule of law and probably still has no respect for the rule of law and still might be reelected.
Did the demonstrations have any impact on changing the ruling later when it comes to the election?
I think to the extent that the Republicans are all singing from the same prayer book, I don't think the protests have any great impact. I think litigation potentially has some impact. Like, for example, the states that do not provide an exception for the life of a woman. Okay, now we have this moral dilemma. Who do you favor? Do you favor the unborn fetus who may or may not get carried to term, may or may not survive birth? Or do you favor the woman who's clearly alive and is related to somebody and has relationships with somebody? I don't know how the court deals with that issue other than saying, you'd have to favor the life of the person who already exists. I mean, if you start talking about the unborn human beings, we get ridiculous situations like the one that happened somewhere in the States, where a woman was driving in the HOV lane in a car by herself. And when she was pulled over, she said, no, I'm here in the car with two people. I'm me and my fetus. Yeah, she was very smart.
Yeah, she was being pretty.
And, up until now, at least in England and Canada and sort of those jurisdictions under the common law, there's this doctrine called en ventre sa mère. That's within the woman. So does a fetus have any rights while the fetus is a fetus? No, there's no rights. When does the fetus gain rights? When they're born. So let's say the parent, the father of the fetus dies and leaves his estate to his wife, but not to his child, or to other people and not his wife. Does the fetus at that point in time have a claim to a share of the estate? No, the fetus has to be born in order to claim any rights to the estate. The fetus as a fetus has no rights. They have rights that are future rights. Let's put it that way. If they're born, they get these rights. If the fetus is injured at the hands of a third person while the woman is pregnant, there's no tort claim. There's no negligence claim for the fetus while the fetus is a fetus. It's only if the child is born that there are legal rights that attach to the fetus. Of course, the US is going in the total opposite direction, where you start talking about the unborn human being and using that kind of language in an actual piece of legislation. Like, where do we go?
Thank you, Eric.
My pleasure.
Thank you to everyone online. I don't know if they can hear me. And thank you everyone for joining us in person. And help yourself some coffee and pastries if you want to take it to go. No problem. And we'll see you next week at this time.
Yep. Thank you.